The doctrine of binding judicial precedent is also referred to as stare decisis. The Latin term means to stand by a decision. Here's how precedent works. In practice, judges when trying cases will look to see whether the legal issues in the case before them have been dealt with before. In particular, a judge will be looking for decisions by superior courts. If a judge finds a precedent by a superior court where the material facts of the cases are the same and which raises the same points of law, they will in most cases be bound to follow it. By following the decisions of the superior courts in cases that raise the same legal issues, the law becomes more consistent and predictable. This means that lawyers can provide clients with clear advice as to how to order their affairs. At the conclusion of a case, the presiding judge or judges will issue a judgment or speech. This judgment can be divided into two parts, the ratio decidendi and the obiter dicta. Ratio decidendi is Latin for the reason behind the decision, and the ratio of a case is the legal principle that was established by the court. This is the part of the judgment that is binding. Obiter dicta means things said by the way. Obiter are statements made by the judge that are not central to the decisions. This could include general statements of law or illustrations of examples of hypothetical scenarios. The doctrine of precedent operates on the basis of the hierarchy of the courts. In order to fully understand the operation of precedent, it is vital that you know the hierarchy of courts and the individual rules that pertain to each court in relation to the operation of precedent. The Supreme Court is formally the appellate committee of the House of Lords, sits at the top of the court structure in the English legal system. The decisions of the Supreme Court and its predecessor, the House of Lords, are binding on all lower courts. For many years, the House of Lords was bound by its own previous decisions. This principle was established in the case of London Tramways Limited versus London County Council, 1898. In 1966, however, the House of Lords issued a practice statement in which they stated that in the future they would regard themselves as free to depart from their own previous decisions. The 1966 practice statement made it clear that this newly created power applied only to the House of Lords and Supreme Court. Here's why the creation of this new power was significant. Number one, the ability to depart from previous decisions is important in order to ensure that the law is able to continue to develop. Number two, it is essential to have a mechanism for the correction of mistakes and errors. Number three, the law must be able to respond to a changing circumstances. If it is to retain its relevance. In the years that followed, the House of Lords used this newly power very cautiously. The case of R versus Shivpuri, 1986, is an example of the House of Lords using this power to correct a mistake that they had made interpreting the law. In the case of Anderton versus Bryan, 1985. With regard to matters of EU law, the Supreme Court is bound by the decisions of the European Court of Justice, as are all courts in the English legal system. Furthermore, the implementation of the Human Rights Act 1998 has led to the decisions of the European Court of Human Rights binding the courts in the English legal system. Below the Supreme Court lies the Court of Appeal. The Court of Appeal is divided into a criminal division and civil division. Both divisions are bound by decisions of the Supreme Court. They are also bound by their own previous decisions, unless the exceptions laid down in the case of Young versus Bristol Airplane are met. These exceptions are where conflict exists between two previous decisions of the Court of Appeal. In such a case, the Court of Appeal can decide which decision to follow. Number two, where the Supreme Court has either expressly or impliedly overruled a Court of Appeal decision. Number three, where a decision by the Court of Appeal has been made per inquirium or in error. However, it is accepted that the criminal division of the Court of Appeal has greater flexibility with regard to the self-binding rule. The criminal division of the Court of Appeal can also depart from its own previous decisions where it believes that the previous decision was made as a result of misunderstanding or misapplication of the law. The example is R versus Tay. Below the Court of Appeal are the divisional courts. These courts are also bound by the decisions of higher courts as well as their own previous decisions, but can avail the exception in the case of Young versus Bristol Airplane. Below these courts is the High Court. They are bound by the decisions of the superior courts. The decisions of the High Court are binding in all inferior courts. However, their own previous decisions are not self-binding but are persuasive and normally followed in practice. Different mechanisms also exist that aid in avoiding the operation of judicial precedent. The first one is distinguishing, whereby a judge can seek to distinguish the facts of these cases they are hearing from the material facts of a case establishing a precedent. A good example of distinguishing can be seen in the case of Merit versus Merit, in which the material facts were distinguished from the case of Balfour versus Balfour. The second tool is known as overruling, whereby a superior court departs from a previously established legal ruling. An example of overruling can be seen in the House of Lords decision in R versus R. The last aid in avoiding precedent is known as reversing it. It occurs when a superior court reverses the decision of an inferior court in the same case. So, to critically conclude this topic, it can be said that judicial precedent allows for consistency, certainty, and efficiency. On the other hand, however, the doctrine allows for a degree of judicial creativity and introduces an element of inflexibility and rigidity in the law, which could potentially hinder the evolution of law.